Hello and welcome to the Rodgers Brief for April 28th, 2023. I'm Adam Rodgers. Thank you for watching and thank you for listening. Got a bit of an exciting announcement coming here in a moment, but first I'll just cover some of the topics that I'll be going through today in the Rodgers Brief, where I cover legal topics on a weekly basis, and usually they're from Nova Scotia, Canadian legal cases or stories with legal angles. Sometimes international, but today it's going to be a Canadian focused program or discussion. I'm going to talk about the electoral boundaries map, which has been finalized for Nova Scotia. There was some back and forth with parliamentarians and a parliamentary committee, and it went back to the electoral boundaries commissioners for Nova Scotia, and they've come out with their decision on the objections that were made by some of the government MPs. I'll talk about that. I'm going to talk about some new federal legislation, one that's just been enacted, which was C11, which is the Online Streaming Act legislation, and the other has been introduced, and this is to do with there's publication bans for certain cases involving sexual offenses. And then also some changes to how the sex offender registry is going to now operate in Canada. This is following a Supreme Court of Canada decision last year that struck down certain mandatory parts of that. So I'll talk about that briefly. And then there's some Nova Scotia cases. Actually, I'm going to talk about a sentencing circle, just some of the nuts and bolts of how that operates. I'm in the middle of one of those now, and talk about some of the timing issues and some other stuff that goes with that. And then I'm going to talk about several Nova Scotia cases, but I'll focus on one, which is a sentencing decision on a drug case that came down last week from Justice Robin Gogan actually it was out of a Port Hawkesbury case. So, but first I want to make a little announcement, and this is that I have a book coming. I've written a book. This is a little bit pre-pandemic. I started on this, but mostly during the pandemic when a person had a little more time in their hands. I mentioned this. It really doesn't have much to do with what I talk about here on a weekly basis, but you'll be seeing some of this in the YouTube stream. If you're following my YouTube videos, you'll be seeing a preview video for this and some promotional stuff which a person has to do. I'm going to be publishing this on Amazon. Those that have been listening in on some of the Rodgers Brief stuff will know that I have published a competing report to the Mass Casualty Commission's final report, which mine was called Deficits of Trust. And I published that on Smashwords, which is an e-book publishing service, and you can get those on different book online sources as well. This time I'm going to be going with the Amazon. It's called Kindle Direct Publishing, and it's a method. You can get the ebook, and it's going to be about a $10 purchase, but you can also get a paperback, which a lot of people prefer to have the physical copy. So I'll be able to have some of those. Now it's not, if you've been following me through these videos and the legal analysis of particular cases and the Mass Casualty Commission, this is not quite that. This is going to be a book of legal and political philosophy. Before law, I took a business degree, but I took a lot of philosophy courses too, and I've continued an interest in that. So it's, I guess an identification of what I see as a trend in legal and political philosophy. It's a change, and then also how a person is going to live under such a framework. And it's aimed at a broad audience, so the people that I'm trying to connect with here through these videos and through the nighttime podcast, other venues where I try to talk to people about legal issues, I'm aiming this at a broad audience and intelligent and curious regular people. I guess that's how I'd put the broad audience. The title of the book is Post-Atheist 21st Century, the Post-Atheist 21st Century. And it's the subtitle is An Evolution in Democratic Governance and Personal Meaning. Now, it's not an anti-religious book, really, despite the provocative title. A person has to have a little bit of a provocative title in there to get people's attention. Actually, the cover, which I'm quite proud of, I designed that myself. That's going to be the cover of it. It's a little creative and provocative as well. Try to get some attention. It's kind of thematically, it's looking at big picture changes over the last few centuries in democratic governance. It's a little bit based on the Thomas Piketty Capital in the 21st century. That's kind of where I evolved the title. And it's looking at sort of a broad trends in philosophy, in political philosophy, and sort of tying these things together. And it came through my work, involvement on the board of Engage Nova Scotia. And people might be familiar with the major, if they're from Nova Scotia, the survey that went out a few years ago about quality of life initiatives and wellness stuff. And it connects to what's going on in different parts of the world, like in New Zealand, Iceland, Scotland, where they've been, doing these wellness budgets, dealing with quality of life measures. So it's governance structures that are free from ideology. So, you've got, nationalist governments, capitalist societies, communist, socialist societies, all with their own structures. And I view these as constraints. They're constraints of, better decision making, which when you're looking at things in a broader quality of life measure, opens up some of those things, breaks down some of those barriers. And I see this as a governance trend that matches sort of, natural selection, the capitalist market, how sort of an open-ended, let's see what happens, let's see what people want. Astrophysics has these same kinds of things. And then there's philosophical trends in science, medicine, and technology that are sort of matching this, right? So what it is evolution free of constraints. And in our governance structures and ideologies, you say, all right, well, is something a good law? Well, does it match the capitalist structure? Well, if so, yes. Well, maybe instead of having those ideological structures and referencing them whenever we need to make a big decision, that we should be thinking in broader terms. So that's kind of where that's the idea of it. It picks up on a jurisprudence paper that I did back when I was at Dalhousie Law School. And you have to do major papers in your second and third year there. My third year was on a question of legal authority since the death of God, which, again, it's a provocative title. It's not talking so much about religion, but of course it does. But it's like, well, Nietzsche declares the death of God, and thus spake Zarathustra. Okay, normally, in the old days, you'd say, all right, well, is this law a good law or not? Well, does it align with what the Bible says, with what we think God would say? Well, if so, yes, and if not, no. Well, without that reference point, without that sort of North Star, you look at, does it fit the capitalist market? Does it fit, is authoritarian regimes appropriate? Are these other ideologies potentially in there? Is it just, scientific? Whatever's possible is permissible. Those are kind of the questions, and so I provided an answer, and I provide a deeper answer. I'm thinking not in terms of just law making, but in terms of governance in this book. So I talk about environmental issues, medical assistance in dying, technology, economic inequality, these kind of big picture questions, and how those can be answered with this new structuralist structure. And so I start with that, and then I say, all right, well, great, you've got this, there's no eternal existence or foundational ideology, so all right, great, how are we supposed to live under those circumstances? Well, you got 70, 80, 90 years to go. How do you find meaning with that? Well, people have that temporary existence. Well, our responsibilities give our lives meaning. What does that mean? Is our whole life relevant, or only the parts that are public, that other people can witness or perceive? I talk about that. And then our technological future, is it going to be more freedom-oriented? Are these technology developments going to be constraining to our freedom? How is that going to operate? And then talk about how understanding the artificiality of all of it, in a sense, a lot of this is artificial. How understanding that can build resilience. So I think it's pretty good. I worked on it for a long time. It's not that long. It's not as long as Capital. I think it's about 140 pages or so. I had a lot more in there, but I didn't hire an editor. I'm self-publishing this, but I worked on it enough that I think I cut out the parts that you didn't need to bother reading. So we'll see how that goes. Just wanted to let people know that because, like I said, it's going to be something I'm promoting through social media and stuff, so I'll be talking about that a little more. All right, so that was more time than I intended to spend on that, but that's that. Okay. First thing I want to talk about here is the electoral boundary. So I'm going to get into the legal issues, which is a bit of a segue, but the Electoral Boundaries Commission. I talked about this a number of times here and in other places. Well, in Nova Scotia, all right, so across the country, every 10 years with the new census data, the Electoral Boundaries Commission, which is an independent third-party operation, resets the federal electoral boundaries. Done so in Nova Scotia, and the commission did some consultations, three-person commission, and sent the report into Parliament. The parliamentary committee, PROC, P-R-O-C, committee that studies this, heard some objections from Nova Scotia Liberal MPs. Sean Fraser, Minister of Immigration, Jaime Battiste, MP for Sydney Victoria, and Lena Diab, who's the MP for Halifax West. And all three lawyers, by the way, which is relevant, and they it's gotten very little media attention, actually. I noticed this, so that they made their objections, and after they make their objections, and the committee approved of those objections, you know, basically they wanted the boundaries to go back. They said they weren't consulted properly, and that they didn't take into account, the changes didn't take into account proper communities of interest and these sorts of things. So, and then Jaime Battiste talked about the UN Declaration for the Rights of Indigenous Persons and how, you know, there wasn't proper consultation in the community of Escasoni, which got moved from Sydney Victoria to the new Cape Breton Antigonish riding, rural Cape Breton and eastern Nova Scotia riding. And so there was lots of complaints from that, and so the committee agreed with those complaints, sent the issue back. This is the procedure, sends it back to the commission to consider. Normally in the past, you know, issues like, okay, you got the name, you know, the name of the new riding doesn't make any sense, like something superficial like that, and the commission would make such changes. Well, this time it was the boundaries, and so I felt this was an attempt by the government to gerrymander these ridings for political purposes, having very little to do actually with the stated issues that they were talking about, and the commission agreed. So this, to me, you know, this is a 25-page report that the commission came out with, just released yesterday publicly, although it was submitted on the 21st to the government, it sounds like. So this should be a major embarrassment, I think, for the government. I mean, they, first of all, made what I think is an illegitimate attempt to gerrymander the ridings in the first place. And now they've been told by the commissioners, the head commissioner of whom is Justice Cindy Bourgeois of the Nova Scotia Court of Appeal, a highly respected judge, that their complaints didn't make any sense. And they, you know, struck down every complaint. The only thing that they agreed with was Sean Fraser's wish that the electoral district not be called Pictou Eastern Shore, but rather remain called as Central Nova. So it shows something about lawyers as politicians. You know, lawyers and different levels of persuasion. You know, lawyers can, you know, sometimes persuade a regular audience of something, or, you know, people that aren't really paying attention, and they, all right, well, that sounds like it makes some sense. But then when, you know, there's a different level of persuasive, you know, effort needed, and precision, and, you know, just logic needed when you're trying to make an argument that's going to be scrutinized by a justice of the Court of Appeal. So and Professor David Johnson from Cape Breton University. I can't remember the third commissioner's name at the moment, but they had very little time for that. I'm going to go through some of the report conclusions. Okay, so they changed the name, and in all other respects it remained unchanged. It said the procedural fairness concerns, so this was the concerns that they didn't go do enough consultation. It said there is no validity to the complaints regarding a lack of notice, the number and location of meetings, improperly changing electoral boundaries shown in the proposal to those in the final report, and lack of consultation with particular communities or groups. It goes through all the notices that they put in the newspapers. It was advertised, social media, YouTube, Facebook, Twitter. Everything was online to be seen if people were looking. It says the Commission exceeded the statutory requirement to hold one hearing for the presentation. They held 8 in-person hearings and 1 virtual, a 9th virtual hearing. So they went above and beyond in that respect. And there was an issue in the Antigonish meeting, actually, which I attended, and they had to move it to a bigger location that day. And the commissioners explained that it wasn't their fault. It was the Minister Fraser's office that started promoting this as open to the public rather than open to those who apply to speak. And so a much bigger crowd showed up, or was, they heard it was going to be a bigger crowd. They moved it to a hotel boardroom, which was able to accommodate everybody. And so they talk about that in the report as well. And they talk about how, so Jaime Battiste, one of his complaints was there was no indication in the initial report that there might be changes to the writings in the later report. Well, they say, well, the contents of the final report clearly reflect the Commission considered the public presentations at hearings and received in writing, and that these gave rise to changes from the initial proposal. That is exactly how the redistribution process is intended to work. They're not bound by their initial proposal. They're supposed to actually listen to the people that come and make presentations, which they did. And so they struck down Ms. Diab's assertion that there should have been a meeting in Halifax West. And then they go on. The Commission responds similarly to Mr. Battiste's allegation of procedural unfairness because the electoral boundaries of the 2 ridings in Cape Breton were different in the final report than in the initial proposal. Mr. Battiste suggests this change came without notice and was a shock to himself and his constituents. He says he had no reason to expect the boundaries in the proposal would be changed in the final report. With respect, this demonstrates a fundamental misunderstanding on his part of the redistribution process. Very critical of him. And then they later say, it is unfortunate Mr. Battiste did not take note of the media reports relating to the Commissioner's work and disseminate it to his constituents. His failure to do so does not equate to a breach of procedural fairness by the Commission. They went through some of the media reports that talked about some of the potential changes. And then given the importance of the issue, the Commission will address in some detail the assertion that the constitutional rights of Indigenous people and the United Nations Declaration of the Rights of Indigenous Persons were infringed by the failure to consult and obtain their views. And Mr. Battiste has threatened to take legal action, so they feel that they should state the accurate state of the law. So when is there a duty to consult? There's the Vanderpeet test from the Supreme Court of Canada. And the duty to consult is kind of a specific thing. It's not just, broadly framed as Jaime Battiste put it. There's a 3-part test. First of all, you have to characterize the right claimed in light of the pleadings. All right. Second, you have to determine whether the claimant has proven that a relevant pre-contact practice, tradition, or custom existed and was integral to the distinctive culture of the pre-contact society. All right. And then thirdly, determine whether the claimed modern right is demonstrably connected to and reasonably regarded as a continuation of the pre-contact practice. So it's not just every decision that might conceivably affect an Indigenous community. It has to be something that has that connection to a pre-contact right. And in addition, and they talk about how Justice Beverly McLaughlin noted this, that it applies to the Crown, not to third parties. And so they talk about how the commission itself is a third party. The commission is not the government. The commission is independent of government, and it's intended to be that way. And they talk about the cases that Jaime Battiste referenced in his communication to the committee, and they said a review of the authorities relied on by Mr. Battiste demonstrates their questionable relevance to the matter at hand. And they go through the cases. There's the Simon 1985 case, R versus Denny 1985, 1990 Denny case, and the Donald Marshall decision. All right, and in those cases, none of them had anything to do. The Simon case was a hunting case, the Denny case was a fishing case, and the Marshall decision was also a fishing case. And in none of those three cases, they say the decision is silent as to any potential treaty rights in relation to the federal constituency in which Mr. Marshall existed, Mr. Simon and Mr. Denny, respectively. So there was nothing that had in any of those decisions a specific reference to the electoral district. So they go through, how, and then it's not pre-contact because a right to effective representation in a settler-imposed system of government cannot be seen as a right held by the Mi'kmaq people prior to European arrival. All right, so that's, it has nothing to do with electoral boundaries. And then they go through the UN Declaration of Rights of Indigenous People. And, Jaime Battiste says, yes, this has been adopted in legislation by the federal government. Well, the commissioners point out, yes, it has been adopted. But part of the act is Section 6 that once the minister must complete an action plan as soon as practicable, but no later than 2 years after the day on which this section comes into force. All right, so the section came into force in 2021. Here we are in 2023, 2 years later, and an action plan has yet to be completed. So there is no action plan. A draft action plan is available, but has nothing to do and speaks not at all to electoral boundaries. So it's still a work in progress. So in conclusion, the Commission says that the objections relating to the duty to consult are without merit, and goes on to deal with the objections from the other members of Parliament as well for the boundaries, and goes through one of the other one that Jaime Battiste had mentioned was the it was going to affect the potential for an Indigenous person to be elected as an MP. And they say, with respect, Mr. Battiste's assertion that Mi'kmaq persons will have reduced electoral power in Cape Breton, Canso, and Antigonish is simply incorrect. And they say now they make up 10% of the riding he represents. They will make up 12.4% of the new riding. That is over double the provincial average of 5.4% of the population. And though the Commission has increased, not reduced, the electoral power of the 5 Mi'kmaq communities in this riding, it has improved, not undermined, the potential to elect a Mi'kmaq member of Parliament. Mr. Battiste's concern in this regard is unfounded. And they made one more criticism of that, and because Jaime Battiste had mentioned that he had a concern that the language weight of Mi'kmaq would be reduced, and that he characterized Cape Breton Canso as a nearly unilingual Anglophone riding, and the commissioners say, to the contrary, this proposed riding has a rich linguistic tapestry of not only English, but French, Gaelic, and Mi'kmaq. Eskasoni's website acknowledges this linguistic diversity and notes their close ties to the Cape Breton Gaelic and French traditions. So, quite the report from the Electoral Boundaries Commission. I went through that in some length because I thought it was important. And anyway, there's not been much media coverage of that, so hopefully people will pick up on that a little bit and see it for what it is. All right, so I'm looking at the, we're at 25 minutes now, so I'm going to go through some of the other stories fairly quickly. They're not they're not ones I was planning to cover in as much depth in any event. All right, so the next thing I was going to talk about is the new federal legislation. C11 has passed. This is the online streaming legislation. It's meant to protect Canadian content in the streaming services, Disney Plus, Netflix, Crave, and etc. Problem people had with this is that it was going to also cover user-generated content. And so there was a lot of concerns about censorship. YouTube, TikTok, other social media platforms worried about algorithms being manipulated so that if you were searching for things from Canada, that you would be forced, in a sense, to go indoor or be directed to Canadian content artificially. And the senators that reviewed this legislation tried to do an amendment that would carve out user-generated content. The Parliament, the government, refused to accept that amendment, while at the same time trying to give assurances that it wasn't being targeted. So it was a little unclear as to whether that's a true commitment or not. We'll see as it goes on. All right, next, the other piece of legislation deals with sexual assault offenses. One side of it is this publication ban issue. And the issue is sometimes, you know, when there's a publication ban, it's meant to protect the victim. Sometimes the victim wishes to speak out, and this prevents them from doing so. And it was brought to the forefront in 2021 in Ontario. A Waterloo woman, I think, was fined $2,000 for violating the publication ban, and it was her own name that she was trying to reveal. You know, so what's going on now is that a hearing will be required. If somebody wants to violate or wants to, you know, have the publication ban dropped, well, they'll have to apply to the court to do so. Problem with that is this, that the perpetrator, the you know, then convicted person, will have the right to have a say as well. Now, the Minister Lametti has said that the only real reason he can think of why a judge wouldn't grant a request to lift the publication ban, if some people want to, you know, they want to speak out on these issues, they should be entitled to, would be as if the revelation of one person's name might effectively reveal another victim's name. Well, that's a fair issue, but that can be dealt with without this blanket requirement. Problem with, you know, there's a delay issue. It can take, you know, a month or 2 months sometimes to get into court to get an application heard. And, you know, if something happens and people feel strongly that they want to talk about it right away, that's a problem. And then it re-victimizes them, because then you have the perpetrator in that's going to have a say as well, and the person has to interact with them potentially, and so it doesn't seem appropriate that would be. It should be the right of the victim to publicize the issue if they feel fit to do so. Second part of that legislation that's coming out and it's going to be debated is about the sex offender registry. Last year, the Supreme Court ruled that some of the automatic registration was an overbroad thing, and so they wanted some amendments to it. The government has now brought in those amendments. Some offenses will still be automatic, like a child-related sexual offense or a repeat offender. For others, it'll be a reverse onus. In other words, so you'll be put on the registry unless you can prove that it's unjust that you are. Rather than the Crown having to show that it's justified that you do. It's a reverse onus. That seems appropriate as well. Last part I'm not quite so sure about. I have to think more or see how the debate unfolds. And this is adding non-consensual intimate image sharing convictions to the sexual offender registry. Harmful stuff certainly, but a different level than sexual offenders. Physical offenses. All right, so that's this new legislation. We'll be watching that as it unfolds. Some Nova Scotia cases this week. Actually, one case I'm just going to mention is a sentencing circle situation that I'm involved in. People may think it's a good process when it unfolds. It's not a simple process. I had a decision on January 27th. A person was found guilty, Aboriginal offender. Made a request that day for a sentencing circle. We are now into May. The next court date, we've had 4 court dates adjourning this because it has to go through Mi'kmaq Legal Services Network to be approved in the first case, and then once they approve it, then it has to go to the chief and council of the relevant band to have their view of it. So now the next meeting of the chief and council, they didn't hear it last month, it'll be May 1st, we'll maybe get it word May 2nd. So it's going to be 4 months, and the person's in custody before they get the sentencing circle potentially underway. So certainly not timely justice. All right, so just a word on that. We'll see if that improves, or if there's a... Anyway, that seems to be a structural problem in sentencing circles. It's something that should be more widely available, but if this is the process, I can see why it's not more widely utilized. Some Nova Scotia cases that were released this week. I'm only going to talk about one of these in any depth. But if you're interested, they're on the Nova Scotia Court's website. There's CK, which is a child protection case where a child was put into permanent custody. You can see some of the factors that go into that kind of a decision. There's 2 PIMP cases with the Court of Appeal. One was Chambers, a self-represented, was trying to have his appeal heard. That was rejected by the Court of Appeal. TJF, you talk about initials and publication bans. This was a human trafficking appeal as well, which was rejected. And then the 4th one that I won't talk about much was Atlantic Paving. It was kind of an interesting case when I read it, which is occupational health and safety violation alleged, which was an undischarged explosive found on a work site. And so problem of, well, that's a violation, a safety violation, but actually they were found not guilty. So a decision there on how maybe a reflection of how difficult it is to get a conviction in occupational health and safety cases. The one I will talk about just briefly was Glenn Boudreau's sentencing by Justice Robin Gogan in Sydney. Alexander McKillop, a former colleague of mine, great young defense lawyer out of Halifax, was the defense lawyer. Scott Miller and Drew McQuarrie for the Crown. Lesson here, the reason I want to talk about it, it's a sort of a lesson on how, or indication of how bad criminals can be at crime. So this person, Glenn Boudreau, he had 775 grams of cocaine, $12,000 in cash, 82 grams of crystal meth, 50 grams of mushrooms, 30 grams of cannabis, 2.5 milligrams of steroids, a digital scale, and 2 phones seized. So a mid to high level retailer or a low level wholesaler in cocaine. You know, that's, you know, at least $50,000 worth of cocaine there. Stopped on the Trans-Canada Highway, Highway 104 Whiteside in May of 2019, 22 years old. He was speeding. He was driving erratically. There was an overwhelming strong smell of marijuana coming from the car when he was pulled over. So lesson to criminals, you know, Jesus, if you're doing these drug runs, stay in the speed limit. Drive normally. Don't get all messed up before you go driving. Don't smoke a joint in the car if you've got $50,000 worth of coke in a shoebox in the back. Anyway, sentencing. Sentencing for cocaine, starting point is usually 2 years for even the lowest level. This, the range the judge said for this level, the high, mid-level retailer, low-level wholesaler, was typically 5 to 8 years. Judge went, Crown requested 4 years. Defense requested a conditional sentence, a house arrest sentence of 2 years. Judge went with 4 years, so below the normal range, but a 22-year-old had a very poor upbringing and with no real guidance. So judge went with 4 years, which is, of course, a long time when you're in jail, and so that's a sentence for that. So anyway, I thought that would be an interesting sort of light into what we see sometimes in the court system. Not always the most brilliant of offenders, or I guess they wouldn't be there. But okay, that's it for today, for this week. Thank you everybody for watching. Thank you for listening. It'd be more to come. You'll see more posts coming out about the post-atheist 21st century. I'll be talking with Jordan Bonaparte and Paul Palango this Sunday night for the nighttime podcast, so tune into that 9:15 on YouTube Live Sunday evening. And otherwise, we'll see you back here next week. So thanks again for watching, thanks for listening, and we'll see you next time.